We're not making up stuff on people. When you're a writer, how do you get your work out?
I don't care what people think. I don't care what they say. They can say what they want to say about me. I don't care. I got the talent to write and keep on writing.
We decided that we couldn't try this in the court of law. We're trying this in the court of public opinion.
Just pay me what you owe me. We putting this out here so you guys can see.
This has given us closure. I'm gonna put it to bed after this. I'm from the Bronx, New York. I was born and raised in the Bronx. I'm a 70s baby, so that ought to tell you how old I am.
From the best city in the world, Chicago, Illinois. I was born on the west side, raised on the south side.
I want to write. He said, write what? I said, movies, films. He said, okay, I'll have my publicist send you a fully color-coded copy of my script.
First, my plans was to make some screenplays. I've written 2 books, 25 screenplays.
And you know what I did? I emailed it to you, William. I emailed it to you in January of 2017 because
Wow.
I was looking for other people who were like me, that were writers that felt they were wronged by Tyler Perry. And
Right, because I know I did the same thing.
you was trying to find people?
I was trying to find people who've been suing Tyler Perry and Oprah Winfrey. I was like, wow, I discovered Tyler Perry was in so many lawsuits. I didn't know what to think at that point.
So we're back. And now we're going over documents that are very important. We were talking about document 1, how everything in that document is so different from our prior cases because this is civil RICO. Civil RICO requires there has to be prior predicate acts that you were connected to in order even to bring a RICO case.
Mm-hmm.
And so under civil RICO, the laws say that it does not require you or the defendant to have won in a prior litigation, or even that they had been convicted or even accused against, and there had been a judgment against them in order to bring a civil RICO case. It's about the predicate acts. And so that is what we did. And we established that in document 31, the defendant said in document 31 that this is a civil RICO act with predicate acts in civil RICO.
Yes.
And what's so ironic about that is because I accidentally opened up the wrong thing. So I want to share my screen.
I can see it now.
Okay. So we were earlier talking about the docket sheet and how we can see these little locks. Okay. It's very important for you to understand what this means. This is something that really isn't meant for us to see. The locks. And the locks on this is a docket sheet that has a list of all the different things that happened in the course of the case. So we're on May 11th, and we had just finished talking about document 31, which was their motion to transfer the case to a judge by name. First of all, that's illegal. Can't ask for a judge by name.
Right.
That's like criminals going to court knowing that a judge is more lenient, saying, hey, I want Judge so-and-so. I had him last year on a different case, and I want him because I know he's going to let me go. Can't do that. Then document 33 showed on May 11th, there were 8 different documents filed. Their answer, we just went over the answer and a little bit. And then we went into return to services again. We was just receiving more and more services, which is fine because, we wanted to show just how serious we were about getting them served. So you see here on document 37 to Oprah Winfrey, right?
Right.
Their answer was due by 4/26, right? I mean, it was served on 4/26, due by 5/19.
Right.
Oprah Winfrey Network was due on 5/7. Was due on 5/19. Lionsgate was due on 5/19, right?
Right.
That's according to this. And Harpo was due on 5/17. Okay? Right here.
Right.
So here, if all of them were due by 5/19, and we go up here, we did a notice of motion, document 40, on 5/19, right? This is May 19th.
Okay.
These were just the returns of service proofs, proving that we properly served them. Whether we put this on the record 30 days after they came on the record, or if we put this on the record in the first day that we received them, does not change the date due, because they know to start counting from the day they were served. They were served on 4/26, and they knew that they have to count 21 days from 4/26 according to the summons, and their answers were due by 5/19 for all 3, right? All 4. Oprah Winfrey, right. Oprah Winfrey Network, Lionsgate, right? And Harpo.
Right. So hold on before you get off of that.
Sure.
What about they modified it on 9/5?
They modified it on 9/5.
Yeah.
Where is that?
When it says a notice of
what
motion.
Number?
40.
On 9/5/2017, we found out that they labeled our notice of motion as a motion for a summary judgment on the pleadings. Nothing. So document 40 is missing, but that was just a notice.
Right.
You probably have it on the email somewhere, but it is absolutely missing from our files. So document 40 was just a notice. It was a notice with the pending action for document 61, which was our summary judgment, Rule 56. So on 5/19, document 41, we motion for, do you know why we motioned for Oprah Winfrey?
Yeah, because hers was due on 5/3, wasn't it?
Down here, we got return to services executed on Oprah Winfrey. Her answer was due on 5/17. You see it?
Yeah.
And that answer was due 5/17. Lionsgate was due 5/19. And Harpo was due 5/17. You see that?
Mm-hmm.
So since we had not received anything on 5/19, since we had not received any documents on 5/19, document 41 was filed against Oprah Winfrey because she was 2 days after, it was the 23rd day. Her date was 5/17, 2036, 35, and 34. All says that she was supposed to, 37, says all she was supposed to do was respond by the 17th. Because we had not heard from her, we put in a motion to default her. On 5/19, as you can see here, there is no answer from Lionsgate. And according to this down here, Lionsgate was due on 5/19. On 5/19, there's only document 39 and 40 and 41 and 42. No answer to the complaint was filed by Lionsgate. So on the 22nd, we filed. Now this is crazy. We filed to default Lionsgate. Okay?
Mm-hmm.
And here they're claiming that Lionsgate filed on 5/22, 2017. This, I don't know how they have document 43 and our entry is 47 for motion to default against them, but they were late as of the 19th. It was too late to file an answer. They missed the deadline.
See, that one don't have it.
So they're claiming that they put our default against Lionsgate in on 5/23, 2017. Do you see that?
Mm-hmm.
But they're claiming it was filed on 5/22, document number 47. Right?
Right.
But on 5/23, there's a document entered on 5/23, which was the application for admissions. This document would have said 5/23 on it if it was entered on 5/23.
Mm-hmm.
It wouldn't say 5/22 on it. So document number, what is it? 47 was filed in the clerk of the court before 5 o'clock on the 22nd. You know how I know? Because we have a stamped copy of it. The document 47?
Mm-hmm.
Here's a stamped copy showing May 22nd. The clerk's office closes at 5. At 5 o'clock when we got there was no answer to the complaint filed into the record. We believed at the time that someone had alerted them to go ahead and file it, and they didn't put this on the record until the next day, although they received it on the same day that we put it in. Because it was in on time. This was before 5 o'clock. But do you see the date it says it's filed?
Right.
It says it's stamped filed on 5/22. This would say 5/23. if they entered it on 5/23. They cannot adjust this date. The date that it gets stamped in by the clerk of the court when they upload it into their system. They cannot alter that date. Because
not to cut you off, but I'm still on that one. And even if they was to put an answer in, it was too late. They weren't supposed to accept it, right?
Right.
So they still would be in default. So we're hoping.
Well, yeah, because they were due on the 19th, not the 22nd.
Right.
They have to, anytime you file an answer after the date that you were required to file it, you have to get permission of the court to put it on the record.
I just want the people to know.
Yes. Anytime you file after the date, you have to get permission to file.
We don't see that nowhere yet.
Nowhere.
Right.
No. Not at all. Let's see if we have anything under defaults here. It says complaint, which describes, identifies the defendant as a party. The plaintiff also has the court issue a summons to notify them that they're being sued. And so let's get down here to questions and answers about setting aside a default. In what situations can a judge set aside a default judgment? Under Rule 60BC, and 60BC says, it has to be a mistake, inadvertent, surprise, excusable neglect, who failed to defend himself, fraud, representation, or misconduct by the party who filed the case. Judgment has been satisfied at release or discharge. The summons and complaint were never personally served to the defendant who judgment was entered against. So set aside your default. The judge must agree that one of these reasons addresses your particular situation and that your circumstances weren't being set aside. And so they ask, is there a deadline for filing a motion to set aside a default? It depends on the specific reason you're asking the judge to set it aside. It also says, because of your mistake, inadvertence, surprise, or excusable neglect, you must file your motion within 6 months after the notice of entry of judgment. Because of the other side's fraud or misconduct, you must file your motion within 6 months. Because the judgment has been satisfied, released, or discharged against you, you must file your motion for a reasonable time. Because you were never really personally served with a summons of complaint, you must file your motion within 6 months after service of written notice of judgment. Do I have a defense for the plaintiff's claims in the case to ask the judge to set aside a default judgment? Technically, you do not need to have a legal defense of the claims the plaintiff makes in the case to file a motion to set aside a default judgment, but it helps if you do for a couple of reasons. The judge might be more likely to set aside a judgment if you have good defense to the plaintiff's claims that might allow you to avoid liability altogether. If you do not have a defense to the plaintiff's claims, you can end up in the same position that you're in now, even worse. So it just says, if you do not file the answer to the court and defend against the plaintiff's complaint, you could get defaulted. Another default judgment could be entered against you. So that's how you get to set your default aside. And if you want to talk about that, that's important too, because that's why I pulled up document 52. So here is the defendant's setting aside a default. And here, these are the issues. And this is real important. Let's go back here. They said that the plaintiff failed to properly serve them, right? And Lionsgate Entertainment. The legal standard, plaintiffs have failed to effect valid service of process on the defendants. Plaintiffs have failed to properly serve the Oprah Winfrey Network and Harpo. Plaintiffs have failed to properly serve Oprah Winfrey. Plaintiffs have failed to properly serve Lionsgate Entertainment. In the alternative, defendants move the court to set aside an entry of default. The legal standard, the examination of the factors show there's a good cause for setting aside an entry of default, right? So here's the problem with this. If you do a motion to set aside a default, right?
Okay.
You do that, they said under 55C, right?
Right.
But it's Rule 60, not 55C. It is 55C, but pursuant to Rule 60. But here's the problem. You can't answer the complaint and then say you weren't properly served.
True.
You put an answer on the record. You were in default, and this should have been the only motion that you filed. When you filed your answer to the complaint and enumerated each document and said yes, no, deny, and all of these different things to the complaint and put in your affirmative defenses, you waive your right to a service of process claim because you did not file a motion to dismiss or a motion to set aside a default judgment, but you intended to argue the complaint. You do both.
Yeah, and also, if I remember correctly, the judge took them out of default without excusable neglect. And he didn't even tell us why he did it. He just did it.
Here, their argument and legal standard is they didn't receive a copy of the complaint to the managing officer. So here, this is our default, right? Mm-hmm. We also, how many were there? Let's do this. Let's go back here. We did documents 47. And was there another default? Oprah Winfrey wasn't included in that one. Mm-mm. I'm trying to find the other default. We said that's their answer to the complaint. And 41. Okay. So let's do this. Brutus. Okay. So now let's look at this. Document 41, right?
Right.
See it at the top on 519. Default judgment is our memorandum of law. We explain all accounts that they failed. We explained they had 21 days of service and their answer was due on April 26th. And defendants they were served on April 26th and were due on May 17th. They didn't answer to the 19th, right? So they're claiming that they weren't properly served. Well, what is this? Summary of service. Lionsgate, Jim Gladstone, Business Affairs. The date was 4/28/2017. Oh, 4/28? Oh, no, 4/26/2017. Oh, that says 28 at 3:10. Okay? Mm-hmm. See that?
There's 3.
Oprah Winfrey was served at 3:07 in West Hollywood.
On the 26th.
Yep. To a physical description of a 30-year-old male, Hispanic. And it says, by personally delivering copies to Oprah Winfrey through the Oprah Winfrey Network. Okay? Lionsgate, Jim Gladstone says, by personally delivering copies to Lionsgate Entertainment. John Doe, security guard, because they have a gate guard, the city of California, because there's so many film companies and elite and major corporations, the state of California allows you to serve your gate guard as if it was you, because they can't allow anybody just to roam around behind those grounds, right?
Right.
Says that's who was served. Here's the summons. There's the stamped copy. And here's proof that she was served. And here's proof that all three were served. And here's a copy of the complaint that was served on that day. Document 41 here shows that we also did a default judgment on 5/19 against Tyler Perry. Do you know why? Because not only was he late on the 11th, it was due on the 5th. And as you can see here, we talked about those other guys there. But our issue was that Tyler Perry didn't have his certificate of service. And we were never served with a copy of document 33. We had to go online to pull down a copy of document 33. We were never served or provided with a copy in the mail. And because we cannot electronically file, we do not have the right to use an electronically filed copy as considered service of process.
Right.
So even though it was on the record, if we didn't have PACER, we wouldn't have seen that. We would have just known that they didn't serve us with their copy of their answer. So 47, here, same thing. Down at the bottom, you can see they said they weren't properly served, but yet it says right here, stamped by the clerk of the court, Lionsgate Entertainment was served by me on 4/19 to Jim Gladstone in Business Affairs. He is the legal department who met him, Mr. Robert Hall, the registered process server, in the lobby. No, in the mailroom. In the mailroom. And these are all the proofs that we paid for ACS Service, a process service company, and that he was properly served. So here we're going to go back to document 52, where they said that they weren't properly served by a general, an agent, or authorized appointment, but their legal department received it directly. And so this was a failed attempt to try to have their default removed based on misinformation and untruths, because they were served by a service processing company and a registered certified process server by hand, face to face.
Right. And that they didn't think they was in default, they wouldn't have put nothing up there.
No, they wouldn't have. So here, this is important. So now they're saying that we failed to do this, that, and the third. But when you go here, which we had open earlier, look what it says. Under 12. Rule 12, Federal Rules of Civil Procedure, Rule 12. Go to 12B. If the court grants a motion, how to present defenses. Okay, Rule 12B says how to present defenses. Every defense to a claim for relief in pleading must be asserted in the response of pleading if one is required, but a party may assert the following defenses in a motion. Lack of subject matter jurisdiction is 12B1. 12B2 is lack of personal jurisdiction. 12B3 is improper venue, and 12B4 is insufficient process, and 12B5 is insufficient service of process. So what does that make their motion to set aside a default if they're claiming this? Proper service. Doesn't that make that a 12B4 or 5?
Right. Yeah.
You lose the right to make this defense.
12B5. Yeah.
Right. And it says a motion asserting any of these defenses must be made before pleading if a responsive pleading is allowed. You can't make any of these if you put an answer on the record. So here's the answers. That's document 33, right? Mm-hmm. That's document 43 and 44. You made an answer to the record. This is a 12B claim. That's 12B. This is 12B6. You cannot make a 12B6 claim using a complaint. You have to file a motion for 12B6 to have the case dismissed if you make a 12B. Here. That's a 12B4 and a 5. Service of process. Their argument for answering the complaint is affirmative defenses. Let me show you something. This is where it gets sticky. You ready? I'm going to show you why that's improper. Remember how I explained Rule 8? Here, these are affirmative defenses. Okay?
Yeah, I know we went over there earlier.
Do you see in these affirmative defenses 12B6, failure to state a claim, service of process?
Wow.
No. So these are, you can only make res judicata and statement of frauds and estoppel and res judicata. Let me ask you a question. In 33, their third affirmative defense is, we'll go down here and end it, is collateral estoppel and res judicata, right?
Right.
So this is RICO.
All day.
You can't claim collateral estoppel and res judicata on a case that is a predicate act under civil RICO. Civil RICO and predicate acts, and you can't claim, and you cannot claim 12B6 and 12B4 and 5 in an answer to a complaint. Rule 8 says these are your affirmative defenses in general. In responding to a pleading, a party must affirmatively state an avoidance of affirmative defense. Those don't have those, but here we are at 12. How to present a defense. Every defense of a claim for relief, any pleading must be asserted in a responsive pleading if one is required. But a party may assert the following defenses by motion. These have to be done by a motion, not in an answer to the complaint.
Right.
But document 33, this is plaintiffs not fairly effective service of process. And this is a 12B6, and this is a 12B, let's see. Insufficient service of process is a 12B5. Failure to state a claim upon which relief can be granted is a 12B6.
Right.
This is an answer to the complaint. And then your third one is proper by putting a collateral stop on res judicata, but it's improper because what did you do? This is what you said. This is what you said, and I ain't forget it. You said that this is RICO. Then you said over here in document 31, you said plaintiff brought the within recovery of civil RICO damages alleging acts of copyright infringement and counterfeit goods. Nowhere did I say copyright infringement in the complaint. But you said civil RICO damages. And then you said, they said that I brought 2 prior actions of the same set of facts of RICO. I have 2 prior RICOs in here. Document 15, right? Did I pull it open? Judge Story, on his orders on 4/17/2017, the original judge in our case says RWS. Okay, this is Richard Story, who was our judge. Says here, plaintiff claims are civil RICO with predicate acts related to copyright infringement and counterfeit goods. The damages which would be awarded if these claims are successful would be monetary damages. Plaintiffs have not shown the court an injury that could not be addressed with a monetary damage or award or with a permanent injunction at the end of litigation. As such, their motion for temporary restraining order has been denied. So, how is it if Judge Story says that we can get monetary claims for copyright infringement and counterfeit goods? So I have a hard time with people doing this to us because here, right? Mm-hmm. It says, I'm going to it. Document 1, we stated in our complaint that it's civil RICO, right?
Right.
And here, do you see predicate acts cluster around criminal copyright plagiarism? Do you see infringement in here anywhere?
No.
No. Predicate acts cluster around criminal copyright plagiarism. Now, 2319 is criminal copyright infringement.
Right.
But that's because it's a predicate act.
Yeah, but you don't see no 506 or no what is it?
No, if 506 is ours, yeah, we put 506 in there.
Yeah, but we didn't.
But not 503 and not 501. We didn't use it as a predicate act, though. Right, as predicate acts. But not 301 or 501. But 506 is criminal copyright infringement. So just see, these are ours here. And so if we want to show the people something, it says 17 USC 506, criminal offense. Any person who willfully infringes on a copyright shall be punished for purposes of commercial advantage or private financial gain by the reproduction or distribution of electronic means for the distribution of being prepared for commercial distribution. For the reproduction or distribution of copyrighted work by itself shall not be sufficient to establish willful infringement of a copyright.
Right.
So this is what we said. And then we also said, circumvention of copyright protection systems. Okay. Then we said 1202. Integrity of copyright management information, meaning grabbing a new copyright on your new film script, knowing that it was based upon our works. And then 1203, civil remedies. So this is not copyright infringement.
Right.
These numbers don't have nothing to do with copyright infringement. So now, let me get back in. So I believe here, let's do this. And we're going through this because we want people to see that we did our due diligence. We worked really hard to prove our point, and this is not what we wanted. And so RICO is any act of criminal copyright infringement, a predicate, or only egregious ones. They're saying, is it only the bad ones or the good ones? So they said they seek 7 causes of action in an amended complaint and the strike synopsis affirmative defenses to the counterclaims of the declaratory judgment of a breach of contract. And I want to move on to 2319 because that's 2318, although that's what they used. But we want to show here what they said and how they ruled on this. The legal standard. See, this is in reference to a 12b6, saying they failed to state a claim. And then the motion to strike. And I'm going to show you. Oh. It says, the Civil RICO Statute 18 U.S.C. 1962 requires a plaintiff to prove that each defendant participated in the conduct, the enterprise that affects the interstate commerce through a pattern of racketeering activity and the proximity harmed the victim. So this whole statement right here, right? You see this? All this. So you got all this. So there's 1, 2, 3, 4, right?
Right.
We did that. We did that when we talked about our cause of action. Here, 1, the defendants, the studios, that's number 1, right?
Right.
So here's number 1. Requires plaintiff to prove that each defendant participated. So we said the studios, Tyler Perry, Oprah Winfrey, and OWN received money from a pattern of racketeering activity, such as violations protected under the Copyright Act, drug money, bribery, threats of financial and physical, counterfeit, forgeries, and intellectual property. Number 2, invested that money in an enterprise of Tyler Perry Studios and Oprah Winfrey Network. So here's, what does it say? Number 2 says, it says an enterprise that affects interstate commerce. Did we not show the enterprise organization of Tyler Perry Studios and Oprah Winfrey Network? Number 3, the enterprise affected interstate commerce. Here's number 3. What does it say here under number 3? Through a pattern, okay? We said the enterprise, so the pattern was it affected interstate commerce, meaning the works were just constantly removed from one place to the next, one state to the next, and all of the movie theaters and all of the different ways that you package it and sell it, Amazon, however you sell the movies and you package them and move them. That was what the enterprise did that affected us through the interstate commerce, right? Number 4, an injury resulting from the investment of racketeering income distinct from an injury caused by the predicate acts themselves. And we explained that they were distinct because the racketeering activity in itself is different from our personal injury, because after they did all those things, they blacklisted us as writers. That affected our ability to make money. And we explain that. So that's what is required in RICO. That the proximity harmed the victim. And we showed that in our complaint. So why am I saying all of that? To say this is because their answer was ineffective. They answered twice. You only get one answer. You either going to answer the complaint or you're going to file a 12B6 or a 12B4 and 5 for service of process. So they did both. Then they turned around and did collateral estoppel and res judicata on the predicate acts. You can't do that on a predicate act under RICO. So I went into RICO for a reason, because I wanted you guys to see, which shouldn't be, right? It says rejecting as RICO predicate act allegations of copyright infringement where defendants were accused of using plaintiff's copyrighted architectural drawings because there was no suggestion of piracy or counterfeiting. In opposition, Synopsis relies on cases that have rejected the Stewart Court's reliance on legislative history, showing a particular concern over piracy and counterfeiting enterprises, and instead applied the plain language of RICO and requires only any act, any act of criminal copyright infringement, no matter its size or impact. And it says in Iconics versus Misero, right? Permitting allegations of copyright infringement stemming from a business dispute between two companies to be a predicate act under RICO. Also asserts that while the alleged infringement might have been small scale in terms with those involved, just the 3 defendants, its allegations are sufficient significance that the claim should be allowed to proceed. At this juncture, I agree. Synopsis alleges a scheme of copyright infringement is allowed when defendants avoid paying millions in license fees for multiple EDA programs that extended for periods of years. That is sufficient for criminal copyright predicate act. So we said, okay, these people are not planning on playing fair. They don't want to answer the charges. They want to act like this is a copyright infringement. So we filed a summary judgment, document 61. Okay, here's our 61. We filed this on June 6th. It's stamped upside down for some reason. And we said motion for judgment on the pleadings, summary judgment. That's Rule 56 that we said right here, Rule 56. And Rule 12C, judgment on the pleadings. So we explained in this document that the complaint and the defaults and the opposition to Pro Hoc Vici, they said, we explained all those documents in here. We explained that they answered our claims under RICO And we showed what we argued, under what we asked for. We showed them this is what it was for racketeering under civil RICO in our complaint, with a 10-year period of similar offenses, that we were entitled to judgment in our favor. And we explained that the motion was based on a pattern. And from 1992 to the current, they did the same thing over and over again. And we said they filed frivolous motions to quash, to reopen the case, to defend RICO violations. We explained that that was improper. And then we filed a memorandum of law arguing these issues in our summary judgment that they were supposed to answer for. We said the defendant's answers are barred by law and should be dismissed pursuant to Rule 12. The defendants failed to follow proper court proceedings for federal rules and laws. We said service of process, defendants failed to file summons and waiver. The defendants failed to file a certificate of service. Defendants failed to file extension and enlargement of time to file an answer. Defendants failed to file for hearings for late filings. The defendants failed to file an appearance of corporate disclosure for all defendants. Defendants during the FRCP 11, during the proceedings, there was no signature on any of their documents. There was no Rule 11 certification on their documents. Defendants failed to answer and defend the civil RICO complaint. We explained that the defendants failed to answer the charges of 18 U.S.C. 1964, Sherman Antitrust Act, and the Hobbs Act, and the First and the Seventh Amendment, which was a demand for a jury, and the First Amendment, which is Article 1, Section 8, for violating our rights. Defendants only responded to 18 U.S.C. 1961, not 1964. Defendants responded to 17 U.S.C. 505 and 505A, which is not in the complaint. We didn't charge them with 505 and 505A. Cases defendants litigated previously on the complaint were not accepted as true. So they said it wasn't true, but it was, because those are cases taken off of PACER. Those are actual cases they litigated, and including they settled on. So you can't say that they're not true because you did settle on them. Defendants refused to admit publicly and announce the announced exclusive partnership with one another. That's RICO Enterprises working together, two corporations. A pattern of racketeering, RICO Enterprise and predicate acts on the defendants were established. Defendants waived their right to file a Rule 12 motion because they answered the complaint with an answer. The civil RICO is sanctionable under Rule 11B because their pleading wasn't signed by the attorney, and they have to have a wet signature on any responses and motions and answers under civil RICO, because that is your attorney's certification that you are positively and confirming that you are not a party of RICO, but you haven't done that. A pattern of racketeering, RICO Enterprise and predicate acts on the defendants were established. Defendants waived their rights. We said that already. Motion to quash was improper. We explained why. We showed you where they were trying to use the motion to quash instead of saying I'm late because I was sick, or I was late because my family had issues and I have documentation from whatever issue that I couldn't get my case done on time. And that was improper because we showed that if you could answer for Tyler Perry on May 11th, then you could have gotten Oprah Winfrey and Lionsgate stuff served into the record before the 22nd. You could have had it in before the 19th and the 17th when it was due, because you already filed for Tyler Perry on the 11th of May, and you're the same attorney for them. And so We explained that the defendants never served us with the motion to quash because we had to go on the record of PACER to see it. There was no notice of motion. Anytime you give a motion to serve on someone, to dispose of something, you must serve them with a notice. We didn't receive notice. Personal jurisdiction and motion to dismiss Barbara Hunt is not applicable under RICO charges because 18 U.S.C. 1965 says personal jurisdiction is held over any of the defendants out of state as long as one in the state have jurisdiction. Defendants defaulted and failed to defend. Defendants' counsel filed an answer for some, but not all. That's what I just said. Questionable if Attorney Gordon represents the other defendants, because why would you file on time? Well, not on time because you were still late for Tyler, but why would you file on the 11th for one group of your of your defendants and not all of your defendants? You know what I mean? And so we said that. We said the counsel failed to appear for all defendants prior to default. Late submissions without leave of the court. The actions of counsel for the defendants exhibit and display behavior plaintiffs expressed in civil RICO. Intentionally defaulting, transferring cases, and reassigning organized crime operation. Conclusion. So these were the laws we used. We used a lot of law and a lot of federal rules and a lot of statutes. And we're like, okay, they're filing document 74 saying this is a motion under Rule 12C, right?
Right.
To dismiss the claims in its entirety on the following grounds. Defendants seek no relief on this motion. You can't ask for a judgment on the pleadings without a judgment. That's illegal. So here are their arguments. They claimed that we're barred from civil RICO based on res judicata. We didn't have a prior case of civil RICO. That plaintiffs are attempting to relitigate previously dismissed claims of copyright infringement, alleging that their filed copyright claims support a civil RICO claim. Here it says, though Tucker purports to cast this case as one for civil RICO and other claims, the underlying issue, as her previous two lawsuits, namely whether good deeds infringes, no, it's not. That is not the underlying issue here. The underlying issue is the defrauding of the court system, the defaults, the improper motions, the threatening of attorneys, not allowing us to properly litigate. Come on. We never litigated that in any court.
Right. Well, they changed the narrative. Yeah.
The plausibility standard. Now they're doing 12B6. See, failing to state a claim for RICO. They're saying even if they're not barred. So now they're saying, well, we know that we're reaching, trying to say that this was litigated before. We know this ain't copyright infringement. So it would fail because civil RICO claims fail. They're insufficient. It says the plaintiff's allegations fail to make out a civil RICO claim. That's 12B6. Look what it says under 12B6. They saying this is a 12C, right?
Right.
Here's a 12C. A motion for judgment on the pleadings. After pleadings are closed, but early enough not to delay trial, a party may move for judgment on the pleadings. It says, here, the result of presenting matters outside of the pleadings if on a motion 12B6 or 12C. So the matters outside of the pleading is our document 1, civil RICO. They're making a claim for copyright infringement. So that's a matter outside of the pleadings. It can't be this is the same merits as the last one, but yet you have to submit documents that are outside of the pleading that we presented in the case to try to make a claim. So it says if that happens, and they're not excluded by the court, the motion must be treated as one for what?
Summary judgment.
Under Rule 56.